we need to take up before I call the case?
I don't believe so, Your Honor.
I don't think so.
Okay. All right. Given that, we will call case number 2019 CR 1344, captioned State of Kansas versus Dennis Kiser. Would the parties announce their appearances, please?
May it please the court, Your Honor, the state of Kansas appears by Crystalline Oswald, Deputy District Attorney.
May it please the court, Your Honor. Mr. Kiser appears by video and with counsel Chris Scott.
All right. We are here set down to take up a plea today. Mr. Kiser, I received your plea petition. In order to take this up, I need to ask you a bunch of questions, okay? If I ask you something you don't understand, I need you to tell me that so you and I can talk about it till we both are sure that we're on the same page. Anytime that you want to talk to Mr. Scott in private before you answer one of my questions, you just tell me. I have the ability to send you to what's called a breakout room so you can talk with him without any of us hearing, okay?
Okay.
All right. Now to do this, I need to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Kiser, how far did you go in school?
High school.
All right. You read and write okay?
Yes, sir.
I know you're in custody, but I have to ask, as you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what we're doing today?
No.
You feel like your mind's clear today?
Yes.
Do you know what you're charged with?
Yes, I do.
All right. And you know you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial in this case. Do you understand that?
Yes, I do.
And I said guilty, but I meant the intent is for you to plead no contest today. Is that correct?
Correct.
Okay, we'll talk some more about that here in a second. But if you decided to maintain your not guilty plea, you would have an absolute right to a jury trial. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Scott would assist you throughout that trial. He would cross-examine all and confront all of the state's witnesses, challenge their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power of the court to make them come. Do you understand all that?
Yes, I do.
Furthermore, at that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to take the stand, the state couldn't use that against you. In other words, Ms. Oswald here couldn't get up and say, well, ladies and gentlemen of the jury, you should convict him because he didn't get up on the stand and tell you his side of the story. Do you understand that?
Yes.
All right. Now, if we went through that full trial, at the end of that trial, you were found guilty, you would be able to appeal that conviction to the appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, I do.
All right. Now, we talked a little bit about the guilty and plea versus a no contest plea. In a guilty plea, you admit the elements of the crime. With a no contest plea, basically, you're not admitting or denying anything, but you're choosing not to contest the state's evidence. Is that your understanding?
Yes, it is.
All right. Now you understand that given that, when we're done here, I'm going to ask the state to tell me what they think the evidence at trial would be. And since you're not contesting that, I'll be able to find that they've established that and determine whether you're guilty or not based on the state's evidence. Do you understand that?
Yes, I do.
Okay. Now I want to pull up real quick here the plea petition that was sent to me. I want you to take a look at this. Can you see that document?
Yes, I can.
Is this the petition to enter a plea of no contest that you and Mr. Scott went over?
Judge, you'll have to take my word for it because him and I just went over it by video, but I did read it word for word to him.
Okay. All right. So if you're seeing what I'm scrolling through here, Mr. Kiser, Does this sound like the what Mr. Scott read to you?
Yes, it is.
All right. Now, I see here where it says the terms of the agreement, and they're as follows. That you're going to be pleading no contest to the 2 counts that are contained in the amended information. That the parties are going to agree to recommend to the court a standard presumptive sentence on each count, and that the counts run consecutive to one another. Is that your understanding of the plea agreement?
Yes, it is.
Has anybody promised you anything else to get you to plead no contest today?
I'm sorry, can you repeat that question?
Yeah, I don't know where those, I think it's bleeding in from the other inmate that must be down there. Has anybody else promised you anything other than this plea agreement that I just read to you to get you to plead guilty today?
No, they have not.
Has anybody placed any force or threats against you to make you plead guilty?
No.
All right. So I see in here, it talks about what the parties are going to recommend for a presumptive sentence or for a sentence. You understand that as the trial court, I will listen closely to everybody's recommendations and take them all into consideration, but I'm not party to this agreement and I'm not bound by its terms, and I can give you any sentence that the law allows me to, independent of any agreement. Do you understand that?
Yes, I do.
All right. So given that, well, first I'll ask, do the parties have an understanding what they think Mr. Kiser's criminal history will be?
Yes, Judge, I believe he will come back as an I.
Me too, Judge.
All right. Well, that's a good thing, Mr. Kiser. That's the lowest criminal history we have. But when we're done here, I'm going to order a pre-sentence investigation, and they're going to take a deep dive into your history and see if there's anything there that the lawyers don't know about. So I can't consider your criminal history determined until we see that PSI and everybody has a chance to comment on it. So given that, what I have to do today is advise you what the maximum that anybody could get for this crime is. In other words, just for today's hearing, I'm going to assume you have the very worst possible criminal history so that I can advise you that the most that anybody could get for these crimes is 247 months imprisonment, a fine of $500,000, and lifetime post-release supervision. Do you understand that those are the maximums in this case?
Yes, I do.
All right. Mr. Scott, we lost your video for a second. Are you still with us all the way?
Yes, Judge.
Okay. All right. Mr. Kiser, do you have any questions about anything that you and I have gone over today?
No, I do not.
All right. Mr. Scott, do you know any legal reason why your client should not plead no contest?
No, Judge.
All right. Then I will ask you, let me stop the share here. As to count 1 of the amended information, which charges you with aggravated incest, a severity level 3 person felony, how do you plead? Guilty, not guilty, or no contest?
No contest.
As to count 2 of that information, also charging aggravated incest, a severity level 3 person felony, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. And as I said before, what I'm going to do now is ask the state to tell me what they think their evidence would be at trial. I want you to listen closely. When they're done, I'm not going to ask you if you agree or disagree, just whether you understand that's what they believe they could put on. Okay?
Okay.
Ms. Oswald.
Thank you, Judge. I'm pulling it up on my other screen to make sure I can see it well enough. In November of 2019, the daughter of the defendant was at her school getting a presentation by Sunflower House workers about body safety and the general things that they do with Sunflower. After that presentation, the kids were asked to write down something they learned or something they were happy about or how they felt about the presentation. And she indicated in that letter or commentary to her school that she was happy that it was happening and that it was helpful for her so that her dad could stop what was going on. That obviously started an investigation into the defendant by Edwardsville Police Department. The address that they were living at the time, that I will put on the record today because they are no longer living there, so I don't have any concern about victim safety at this point, was 406 River Falls Road, Apartment E in Edwardsville, which is in Wyandotte County, Kansas. When she went to Sunflower House to be interviewed by their interviewers, she indicated that there were some times, I'm going to call them cuddle times for lack of a better term, some times that she would be with the defendant in his bed. He or she would be in some measure of undress, but more like pajamas, maybe had boxers on or shorts, something like that, never fully naked. She would never allege that either one of them were fully naked, and that there would be some tickling and cuddling, and that it would be touching her in her genitals and under her if she had a bra on. She's not old enough to wear a bra, but if she had a bra on her breast area, that type of thing. She detailed a number of occasions that would happen. I think it was often on the weekends. She would indicate that they would have this time, and she told her mom about it at some point. Her mom tried to stop the activity, I think not necessarily realizing how far it might have been going, but she was quite clear in her Sunflower House interview to allege what would have counted certainly as lewd fondling of her genitals and her breast area by her father, which was originally charged as aggravated indecent off-grid person felonies because she fell under the age of 14 at the time these incidences occurred. Through our plea negotiations, the victim and her mother and the defendant's other son or other child have all moved out of state. They are in another state now. I have spoken with the mother multiple times about the situation, about the possibilities. They have all indicated that they want this to be resolved without a trial. The defendant, to his credit, has always indicated that he did not want to put his daughter through testifying or anything like that. And so we were able to come to an agreement that he plead to aggravated incest, as I've alleged it, that which is a severity level 3 person felony, that we would agree to jointly recommend consecutive sentences for him. That would obviously save him. The benefit of the bargain for him is that he's not now facing Jessica's Law charges. It also has a 25-year registration requirement instead of lifetime, but it does still carry lifetime post-release, as I've reviewed the statute relevant for post-release for a sexually violent crime. And so that was the agreement we came to. It was with the acknowledgement and allowance or agreement of the victim and the family. And I believe Mr. Kiser as well, given his desire to save his family from having to go through anymore.
All right. So suffice it to say that it's a little bit of a legal fiction to join this factual basis with the actual charges, but that the defendant is deriving a benefit from the bargain in able to plead to a lesser crime that maybe the elements don't directly add up to. Is that your position, Ms. Oswald?
Yes, and that certainly, if believed by a jury at trial, the factual basis I put on the record would suffice for his original charges.
Right.
Yes.
Mr. Scott, do you agree with all of that?
Yes, Judge, and I would even say that if anything, I was the holdup to the deal because we had this thing almost to the finish line, and then I brought up the idea of, is there anything where my client could have a benefit of not lifetime offender registration? And this is what myself and Ms. Oswald came up with, presented it to Mr. Kiser, and he was more than willing to go on with it. But honestly, Judge, it wasn't even Mr. Kiser asking for that. It was me looking for something that we could do without lifetime registration.
All right. I wanted it to be clear for the record in case there was ever some sort of an attempt at an appeal based on the factual basis not supporting the elements of the crime. And while I think that's true, we've also, there are case law there that says that to give the defendant a benefit of a bargain, that these legal fictions can, certainly if they support the original charges or higher charges, that they can be done in this if everybody's in agreement with that. So Mr. Kiser, do you understand that the state believes that if they went to trial, that's the evidence they would be able to present?
Yes, it is.
All right, thank you. Given my review of the official file, the plea petition, and the amended information, I do find that the defendant has freely, voluntarily, and intelligently entered into this plea of no contest. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis with the defendant deriving the benefit of the bargain to support the charges as amended. And therefore I will find the defendant guilty of the 2 charges, both of them aggravated incest, severity level 3 person felonies. I'm going to order a pre-sentence investigation be prepared. We haven't really, I haven't gotten a date from my assistant yet, but let me take a look at the calendar and I think I can probably come up with one. What does January 29th at 1 p.m. look like, Mr. Scott?
I can do that, Judge.
All right. And that's only, well, I guess it is about 6 weeks away, so that should work out just fine. Miss Oswald, are you free that day as well?
Yes, Judge.
Okay, then I am going to set our sentencing for January 29th at 1 p.m. Mr. Scott, by any chance, I didn't look at the bottom of this plea petition. Does it have a PSI request attached?
I forgot, Judge. I can fill that out if needed.
Here's what I'm going to do. I can do this. Miss Oswald, myself, and Miss Lowe can leave, and I'll let you 2 talk if you need to get some information from your client for that.
I have all his info, Judge. I can get all his info from the
Oh, okay.
discovery file.
So will you just, do you know who to email it to over at probation?
No, who do I need to just tell me? I'm sure I probably have their email.
Jesse Johns and
Okay.
Ryan Duckers.
Okay.
Yeah, just email them that document and that'll get it going. All right. Other things for our record today.
Nothing other than to tell you, Judge, just that I know that there will be no attendance by the victim's family, but I do believe there's likely to be a letter. When I receive that, of course, I'll forward it to you, but for purposes of timing, I do not expect there to be any victims here to speak.
All right, and let Mr. Scott see it as well, please.
Right.
All right. As a convicted felon, Mr. Kiser, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. This is a crime that will require registration. I believe the period is 25 years. So you'll need to, before you're released, make sure that you're aware of your registration requirements, because failure to live up to those can lead to additional charges, okay?
Okay.
Artie, thank you. We'll see you all on the 29th. We are adjourned.
Judge Fortang, I don't think the court has any control over this, but I know Mr. Kiser was wondering if he could be sent back to Andrew County pending his sentencing.
We'll ask Deputy Gambrell there if he can put in a good word for us. Oh, he can't hear us because of we're off the record. They don't have to listen to me, but I often will tell them, and I'll go ahead and send an email going, he'd like to go back to Andrew County. Inmates seem to like